Hello everyone, I thought I'd give a pretty brief overview, superficial look at the 9-0 Supreme Court ruling that came out April 10th, 2025, yesterday as of recording, which pertains to the application to vacate the injunction entered by the United States District Court for the District of Maryland. And so pretty much this is just the Supreme Court's ruling on the government's wish for this ruling by the District Court of Maryland to cease, pretty much. And I've got some pictures and citations accompanying this, so yeah, I figured we'd just get right into it. Okay, so on March 15, 2025, the United States removed Kilmar Armando Abrego Garcia from the United States to El Salvador, where he is currently detained in the Center for Terrorism Confinement, CCOT. Now, we can take a look at what CCOT looks like over here. We can see a top-down view of the compound. Pretty bleak, bare bones. Looks like a pretty scary place for these guys. Shaved heads, packed in tightly, minimal clothing. Yeah, I bet these guards aren't giving them the best of time. Probably not the resort you'd like to stay at. The United States acknowledges that Abrego Garcia was subject to a withholding order forbidding his removal to El Salvador, and that the removal to El Salvador was therefore illegal. The United States represents that the removal to El Salvador was the result of an administrative error. The United States alleges, however, that Abrego Garcia has been found to be a member of the gang MS-13, a designated foreign terrorist organization, and that his return to the United States would pose a threat to the public. Abrego Garcia responds that he is not a member of MS-13, and that he has lived safely in the United States with his family for a decade and has never been charged with a crime. On Friday, April 4th, the United States District Court for the District of Maryland entered an order directing the government to, quote, facilitate and effectuate the return of Abrego Garcia to the United States by no later than 11:59 p.m. on Monday, April 7th. So quite the order, very fast time here. On the morning of April 7th, the United States filed this application to vacate the District Court's order. So that is what the vacate was, vacate this injunction. On the morning of April 7th, the United States filed this application to vacate the District Court's order. The Chief Justice entered an administrative stay and subsequently referred the application to the court. The application is granted in part and denied in part, subject to the direction of this order. Due to the administrative stay issued by the Chief Justice, the deadline imposed by the District Court has now passed. Of course, this was released April 10th, and the injunction had a deadline of 11:59 p.m. April 7th. To that extent, the government's emergency application is effectively granted in part, of course, and the deadline in the challenge order is no longer effective. The rest of the District Court's order remains in effect, but requires clarification on remand. The order properly requires the government to, quote, facilitate Abrego Garcia's release from custody in El Salvador, and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. The intended scope of the term effectuate in the District Court's order is, however, unclear, and may exceed the District Court's authority. Okay, let's see where the contention is. The District Court should clarify its directive, with due regard for the deference owed to the executive branch in the conduct of foreign affairs. For its part, the government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. The order heretofore entered by the Chief Justice is vacated. So pretty much to sum up this paragraph, some parts of the application submitted by the government to stop the order by the United States District Court for the District of Maryland have been granted by the United States Supreme Court, while other parts of the application by the government have been denied. So let's look at which parts have been granted. Of course, the government wanted the deadline to cease. So to that extent, the deadline that has been challenged is no longer effective. Okay, so the government won on that front. The Supreme Court ruled that the order by the United States District Court for the District of Maryland properly, so this was correctly done, required the government to facilitate Abrego Garcia's release from El Salvador. So the Supreme Court is saying, executive branch, you are bound by this injunction to bring Abrego Garcia back into the United States, as well as to handle the case as if he had not been improperly sent to El Salvador. Now here, the Supreme Court has some issue with the language of the injunction, specifically the term effectuate, and believes it could be a separations of power issue, as the authority for foreign affairs is held within the executive branch. And thus, the Supreme Court orders the district court to clarify its directive. Now, the Supreme Court also rules that the government should be prepared to share information on further action. Now, continuing this ruling, we have statements from Justice Sotomayor, with whom Justice Kagan and Justice Jackson join. And this is not a dissenting opinion, as their ruling respects the court's disposition on the application. So they agree with the ruling of the Supreme Court, at least to a point not to dissent to it. So let's take a look at what they said. As reads, the United States government arrested Kilmar Armando Abrego Garcia in Maryland and flew him to a, quote, terrorism confinement center in El Salvador, where he has been detained for 26 days and counting. To this day, the government has cited no basis in law for Abrego Garcia's warrantless arrest, his removal to El Salvador, or his confinement in a Salvadoran prison. Nor could it. The government remains bound by an immigration judge 2019 order expressly prohibiting Abrego Garcia's removal to El Salvador because he faced a, quote, clear probability of future persecution there and, quote, demonstrated that El Salvador's authorities were and would be unable or unwilling to protect him. Now again, I couldn't find the exact 2019 immigration judge's order, the withholding of removal. However, like I've stated, it's cited multiple times in the current legal case regarding Garcia, so I have no reason to contest that. Sotomayor also writes, the government has not challenged the validity of that order. Instead of hastening to correct its egregious error, the government dismissed it as an, quote, oversight. The government now requests an order from this court permitting it to leave Abrego Garcia, a husband and father without a criminal record, in a Salvadoran prison for no reason recognized by the law. The only argument the government offers in support of its request, that United States courts cannot grant relief once a deportee crosses the border, is plainly wrong. See Rumsfeld v. Padilla. Well, over here we actually do have the Rumsfeld v. Padilla case from 2004. Thank you to Justia for providing these legal texts. And I'm not going to go through the entire case with you, but we are going to get to a highlighted section here right at the end of the opinion, where they say the District Court of South Carolina, not the Southern District Court of New York, was a district court in which Padilla should have brought his habeas petition. We therefore reverse the judgment of the Court of Appeals and remand the case for entry of an order of dismissal without prejudice. Now, that's a whole lot of legal jargon, and without knowing the specific facts of the case, it can be pretty confusing how this relates to Abrego Garcia's case. But in summary, pretty much this alien that was designated a terrorist from 9/11 and in support of Al-Qaeda was taken over state lines, over borders, to South Carolina, and he petitioned for habeas corpus within the Southern District Court of New York, and the Supreme Court could not give a remedy unless he filed in the jurisdiction of the court in which he was detained, which would have been the South Carolina District Court, because he was brought over state lines to South Carolina after being in detainment from ICE. Now, if we take a look, we can see that they cite a second case, Boumediene, I think, sorry if I butchered that name, Boumediene versus Bush. And if we take a look at this case, again brought to you by Justia, thank you, Boumediene versus Bush, 2008, we can see right here in this ruling, the government's premise that de jure sovereignty is the touchstone of habeas corpus jurisdiction is unfounded. And if we take a look further in the ruling, what we see as a common thread is that the idea that questions of extraterritoriality turn on objective factors and practical concerns, not formalism. So just because Abrego Garcia is held within an El Salvadorian prison does not mean that the U.S. and the U.S. courts does not have jurisdiction over that land. Okay, let's turn back to the ruling. The government's argument, moreover, implies that it could deport and incarcerate any person, including U.S. citizens, without legal consequence, so long as it does so before a court can intervene. And so Sotomayor cites this case here, which we do have. So we can see here from the April 7th Supreme Court ruling, if we scroll down, we do see Sotomayor saying, the court then set an emergency hearing for 5 p.m. that same day, at which it planned to consider plaintiff's claim that temporary relief should be extended to a class of all non-citizen subjects to the anticipated proclamation. Despite notice to the government of the court's scheduled hearing, Department of Homeland Security continued to load up the 2 planes with detainees and scheduled their immediate departure. 2 flights, quote, were scheduled for this afternoon that may have already taken off or will during this hearing. That was from March 15th. From April 3rd, government counsel agreeing that DHS was, quote, acting in preparation for the proclamation before it was posted. Returning to the ruling, because every factor governing requests for equitable relief manifestly weighs against the government, Noem versus Holder. So as we can see here from the Noem v. Holder case, 2009, this case involves a statutory provision that sharply restricts the circumstances under which a court may issue an injunction blocking the removal of an alien from this country. Sound similar? The petitioner maintains that the authority of a court of appeals to stay an order of removal under the traditional criteria governing stays remains fully intact and is not affected by the statutory provision governing injunctions. The Supreme Court says, we agree with petitioner. So the equitable relief in question is the court's ability to stay or block government's action. Sotomayor continues, I would have declined to intervene in this litigation and denied the application in full. Nevertheless, I agree with the court's order that the proper remedy is to provide Abrego Garcia with all the process to which he would have been entitled had he not been unlawfully removed to El Salvador. That means the government must comply with its obligation to provide Abrego Garcia with, quote, due process of law, including notice and an opportunity to be heard in any future proceedings. And we have Reno v. Flores 507 cited. And taking a look at this Reno v. Flores case, we can see it pertains to a class of alien juveniles arrested by the Immigration and Naturalization Service. Okay, so not exactly the same, however, it is a class of aliens, and we can see in Part B of the opinion, existing INS procedure provides alien juveniles with, quote, procedural due process, as well as substantive due process. So we do see that citation is correct. It must also comply with its obligation under the Convention Against Torture. See Convention Against Torture and Other Cruel and Inhuman or Degrading Treatment or Punishment. December 10th, 1984. Now, of course, we do have that United Nations Treaty Series from 1984, and we can see, if we scroll down a little bit, it does relate to extradition of a person to another state where there are substantial grounds for believing that he would be in danger or be subjected to torture. Now, I don't know about you guys, but do you think these inmates could be subjected to torture? Let me know in the comments below. The statement by Sotomayor continues, federal law governing detention and removal of immigrants continues, of course, to be binding as well. See 8 U.S. Code, section 1226A, requiring a warrant before a non-citizen, quote, may be arrested and detained pending a decision on removal. Now, if we take a look at that 8 U.S. Code, section 1226, we can see its subsection A pertains to arrest, definition, and release, and we can see that it is all based on a warrant issued by the Attorney General. With the exact verbiage, an alien may be arrested and detained pending a decision on whether the alien is to be removed from the United States. We can also see 8 CFR section 287.8 C2II, which supposedly requires the same as the former. Now that does check out here in the Code of Federal Regulations, section 287.8, standards for enforcement activities. We scroll down, we can see subsection C, subsection 2, a warrant of arrest shall be obtained except when the designated immigration officer has reason to believe that the person is likely to escape before a warrant can be obtained. And we can see in Sotomayor's statement another reference to 8 CFR section 241.4 subsection L, in which to revoke conditional release, the government must provide adequate notice and, quote, promptly arrange a, quote, initial informal interview to afford the alien an opportunity to respond to the reasons for the revocation stated in the notification. And if we take a look at that Code of Federal Regulations, section 241.4, we'll see subsection L pertains to the revocation of release, and we do see the alien will be afforded an initial informal interview promptly. Moreover, it has been the government's own well-established policy to, quote, facilitate an alien's return to the United States if the alien's presence is necessary for continued administrative removal proceedings, in cases where a non-citizen has been removed pending immigration proceedings. See U.S. Immigration and Customs Enforcement Directive 11061.1. And as we can see, Directive 11061.1 by the U.S. Immigration and Customs Enforcement, subsection 2 does refer to ICE's facilitation of the alien's return to the United States if either the court's decision restores the alien to lawful permanent resident or the alien's presence is necessary for continued administrative removal proceedings, which in this case, it does pertain. And Sotomayor concludes here, in the proceedings on remand, the district court should continue to ensure that the government lives up to its obligations to follow the law. Well, guys, that pretty much ends my attempt to be brief on this 9-0 Supreme Court ruling. Let me know what you guys thought in the comments. If you made it this far, thank you. I appreciate it. This is my first video. If you liked what you saw, or if any of this was informing to you, I'd greatly appreciate a like and possibly subscribe, as I will be trying to bring more content like this to this channel. Thank you all for watching.